Hi, Joy.
Hi, Olamide.
How are you doing today?
Oh, great. And you?
Yeah, I'm very well. So, how's your week been?
Well, like every other work week, I suppose.
I know we're caught on vacation, so I expect that there will be some reprieve.
Oh, really? Has it changed for you? Because it
Well, it's not
hasn't changed.
exactly, but yeah.
Yeah. I
Okay.
mean, well, yeah.
Yeah, so today we'll be discussing how parties should be managing their disputes in commercial transactions. Um, Essentially, the idea behind this topic is just to enlighten people on the need to have dispute resolution clauses and for them to pay attention to these dispute resolution clauses in their agreement, and also how to manage disputes when they arise in contracts, because parties more often than not do not prepare for the dispute. So when disputes happen, they're caught unawares. So it's usually very necessary for them to manage this dispute, and they're not caught unawares when it happens.
Yeah.
Yeah, we know you don't. No one prays for a dispute to happen. You want the commercial transaction to have a smooth flow. So you start the transaction starts very well, it ends very well, and both parties are happy. But there are times where one or two things might cause a dispute. So I'll just be throwing like the first question to you. So how do you think parties can manage their disputes in commercial transactions?
Well, to be honest, I agree with everything you've said so far. I should start with that. Parties can manage their dispute by first of all thinking about their disputes even while they negotiate their contracts. Now, what do I mean by that? So you find that most times parties just negotiate a contract and it's all about the business and closing the deal and moving on, and they don't actually think about what could go wrong until it actually goes wrong. So I think the best way to manage the dispute is to think about the dispute while negotiating the contract, understanding that the dispute resolution clause is just as important as every other clause in the contract. Because as a matter of fact, nobody prays for a dispute, right? But we find that more often than not, they occur. And when they do, a pending dispute, a running dispute has the ability to cripple the progress of the contract entirely. So
Yeah.
parties have to negotiate the dispute clause as they negotiate other clauses in their contract. That's what I would say.
Yeah, I totally agree with what you said as to parties having to negotiate their dispute clauses as at the same time negotiating the main agreement itself, because
Yeah.
most times parties don't really seem to think that a dispute would occur. Not that anyone anticipates a dispute, but it's always very necessary to prepare for a dispute. And like you rightly mentioned, one of the first step is usually thinking about the dispute and preparing for it. So a dispute resolution clause in your agreement should not just be an afterthought.
Yeah.
It should be
No,
something
sure.
that you're very well aware of, and
Something that you've prepared for.
exactly. So when you're going when a dispute occurs, you know how exactly you're going to trigger a dispute resolution
Yeah.
mechanism,
Yeah.
and that's usually going to be
Yeah.
the first step. So yeah, and that would not lead me to the point. What exactly do you think would be the key elements or the key factors of preparing for a dispute while negotiate, or
Oh,
the
great.
key elements of negotiating a dispute resolution clause?
Oh, great. So I think first of all, you want to think about the mode of dispute resolution. Now, when I say the mode, so you see, there are different modes of dispute resolution. So there's mediation, there's negotiation, there's expert determination, there's arbitration, and then there's litigation. That's very common, and I'll just take the opportunity to say not very efficient in Nigeria. Pardon my choice of language, but it's what it is. So you have to think about the mode of dispute. You want to choose a dispute clause that is specifically tailored to your kind of transaction. So personally, I would recommend that what I would have in mind if I were to think about my mode of dispute would be, for instance, the value of my transaction. And it's not just like the monetary value. Sensitivity of the transaction, the nature of the transaction is also a value of the transaction. When you think about that, when you think about the mode of dispute, you want to think about the law. And I'll give a classic example. So we have most most businesses are multinational. Is that the word to use? It cuts across different jurisdictions, different countries, some of which operate different kinds of laws. So you want to think about the law that will govern your dispute, just as you think about the mode, and then you also want to think about the venue. Again, some of these things, such as the law that will govern your dispute, the choice of law, and the jurisdiction, that's what I refer to as venue. Some of them will be influenced by the mode of dispute. So they're all intertwined. They're just stuff that you have to think about all at the same time. Yeah.
Yeah, so I actually, from what you've said now, I can say for sure now that when I'm negotiating my dispute resolution clause, I should have in mind the value of what that transaction is.
Yeah.
So what that transaction means to me.
Yeah.
So, for instance, a party that doesn't want the details of the transaction in the media or
Exactly.
to reside with the general
Yeah.
public would prefer a dispute resolution mechanism such as arbitration or mediation,
Yeah.
where the details of the dispute are, and even the transaction ultimately are kept
kept
private between the parties.
Yeah.
But on the other hand, if it's a dispute where parties probably don't even have the funds to
Exactly.
go to arbitration, they would prefer to just approach the courts
Exactly.
and have the dispute
To be
settled
honest, it's easier
in,
that way.
in,
It's
in
easier.
court. So I'll now go to the another part of managing your dispute. So
Yeah.
this is us preparing for the dispute. So when the dispute now happens, how exactly are parties meant to prepare? So you don't know when exactly the dispute will happen. But when the dispute happens, how do you now approach the dispute, or how do you think parties can approach the dispute?
Okay, so I'll approach my answer to this question on the understanding of several basic. Let me use the word principles. First of all, that parties have negotiated the dispute clause, that they've averted their mind to the value of their transaction, and maybe let's use a case study. It's maybe we're looking at a construction dispute, right? We're looking at a time-sensitive, high-value construction dispute. The parties have agreed to a mode of dispute that's double layered, multi layered. So you have them saying, okay, we're going to take maybe 60, 90 days to try and negotiate, settle amicably between ourselves. If we're not able to, and then let's imagine they're not using a standard contract like all the FIDIC books, it's just a general contract. And so they say, okay, we want to approach mediation, right? We want to approach mediation, and if that doesn't work, if we're not able to have a mediator resolve the dispute, or if a mediator resolves the dispute and, well, it's not, we're not able to, with mediation, for instance, it's not necessarily binding unless the parties like agree to make it so. So we could mediate, we could have a mediator's decision. But unlike arbitration, that you have a law that says, well, go and enforce, you can't do that. So let's say parties have agreed will mediate, but then they've also anticipated that we could be done mediating and it still doesn't work out. And so one party can then initiate arbitration, right? And now a dispute has occurred and you're saying, what do the parties do? Now, my first approach would be to, again, at that point, think about your dispute clause. So you want to follow the prescribed mode of dispute resolution in your contract so that you don't get into trouble down the line. So first of all, naturally, I should imagine that a business person in that situation will first of all consult a lawyer. Because first of all, if you're supposed to declare a dispute, you want to make sure that you do declare a dispute. If you're supposed to try to amicably resolve within a certain number of days, you want to make sure that you do that. If the next step is mediation, you want to make sure that you do that. If the next step is arbitration, you want to make sure that you do that. I know that sometimes, and maybe let's now imagine, let's give it a little twist. We're dealing with two Nigerian companies. We can be hot-blooded here. And so the first thing you want to do is to go to court, man, because you want to file something so that you say you filed something, so that but you don't think about, so it's an easy basis to have your suit struck out, and it's a condition precedent argument, for instance. So what that means is you've skipped your entire dispute resolution process in your agreement, and you've gone to court. Someone would simply just raise an objection and say, well, we did agree to resolve our dispute in this way. Parties are bound by the terms of their agreement. He hasn't complied with the different, the multi-layered dispute resolution mechanism we agreed to. So that means he hasn't complied with condition precedents to even like ventilate this dispute. And it's even worse if it's arbitration, because then we have the Arbitration Act that says well, the court has to stay proceedings. And so you've spent money for what it's worth. You've spent money, you've spent time, and you still have to go back you have to go back and start from the first step. So you want to think about your dispute clause again at this time. You want to make sure you follow the steps that you have agreed to. And I think it's always best to have a dispute resolution lawyer at your side when doing
Okay,
that.
so
Yeah.
essentially what you've advised is it's always best to consult a lawyer when
Exactly.
you feel like a dispute has occurred.
Yeah.
And at the same time, you should always have like reference, and which I completely agree with. You should always have reference to the contract or the dispute resolution clause, because it forms part of the main contract itself. So you going contrary to whatever dispute resolution clause that you have agreed to for one reason or the other would mean that you're also breaching the agreement that you have entered
Exactly.
into.
That's
And
another
most
thing to
times
think
courts are usually, and these days I must say that courts are inclined to always respect the wishes of the
wishes of
parties
the
as they
party.
actually
Exactly.
put it in their agreement.
Yeah.
And this
And,
goes
and,
back.
and just to also mention, sorry, right? Let's think about it from the practical aspect. Well, it depends on what your motives are and what your strategy is. It can be a waste of time and money, because I want to imagine that if you haven't followed the steps, the other party will. So you have a case in court, you have an arbitration somewhere, and then it's just different proceedings. You're spending time, you're hiring counsel, and all of that.
Exactly. So it goes back to the first point of preparing for the dispute.
Yeah.
Because when you have prepared for the dispute has now arisen, and you're looking for the appropriate method to resolve that
Exactly.
dispute. You have to
have to
you want to be sure that
yeah.
you are going by what you had
What
already
you agreed.
anticipated and what you had
Exactly.
agreed on.
Exactly.
So that way,
And that's why you have to think long term when agreeing. So if this multi-layered mechanism doesn't work for you, why did you agree to it? If you
Yes.
had imagined that a dispute would arise and you would want to immediately rush to court, then why did you agree to this?
And that's totally I totally agree, and it also goes back to the point about choosing the law or whatever law that would govern your
Yeah.
agreement, because these days we have international trade agreements between companies from different countries. So you probably have an Italian company entering into a partnership with a Singaporean company in Nigeria. So you have three jurisdictions involved in this
Exactly.
instance, and everyone wants to ensure that their own rights and privileges under the contract are very well secured. So parties need to be sure that they're not just copying and pasting
Yeah.
precedents when it comes to dispute resolution clauses.
Yeah.
They need to be sure, and they need to be sure that
Yeah, I just
it's a
remembered
dispute.
something I read on Twitter, but when
Yeah.
you're done, I'll just mention it.
So they need to be sure of a dispute resolution clause that actually will not necessarily, it doesn't have to be in their favor, but wouldn't pose so much inconvenience
On all
to
parties.
whichever party when the dispute in fact arises. Yeah, you were going to say something.
Yeah, so I have a friend, and I don't know the full details of the dispute, but it just it's. I remember the way you were talking about copying and pasting dispute clauses. So the nature of the dispute did not even warrant arbitration. It wasn't a high value dispute. It wasn't a sensitive dispute, but I think they had just copied an entire contract that now had an a Switzerland seated ICC arbitration clause.
You're agreeing to an agreement, you're agreeing to a dispute clause, and you're not looking at the intricacies of the dispute clause.
Exactly.
You're not looking at what the eventual cost will be when the dispute actually arises. And that still goes back to what we are discussing, managing your disputes.
Yeah.
Because when you're resolving your dispute, you're going to incur costs.
Exactly.
You're not only going to incur costs of lawyers, or maybe a potential loss from that particular agreement. You're going to incur losses as costs rather, as to where you're going to be having the disputes resolved.
Exactly.
So you are a Nigerian company, both of you are Nigerian companies, and you decide that you want to have your agreement arbitrated upon somewhere in
I mean, you actually
either
agree on a venue, not a
eh,
seat. Do you
you're
understand?
both
You
in
agree to have
Nigeria.
a venue in Switzerland. It doesn't make
Well,
sense.
it might be good for tourism sake, but I don't think business-wise
It's a
it
smart
will be the
decision.
best
Yeah.
option
Yeah.
for you as a party. But
Exactly.
I think you've been able to give a lot of insight, and we've actually highlighted points
Yeah.
for people when they are negotiating their agreements, particularly as it relates to disputes that might actually occur from this agreement. So parties should first of all think about their disputes, and this is me just summarizing what we've said here
Yeah.
today. Parties should think about their disputes. They should ensure that they negotiate their disputes along along the lines of what they want from the dispute and from the contract, and what they can also afford, because that was the point that came up
Yeah.
at the latter part
Yeah.
of the discussion, and the aims of the transaction itself,
Yeah.
the nature too,
The nature
which
of the
which generally encompasses everything, in the sense that they if it's an agreement that they do not want in the public eye, they also want to ensure that they are protecting
Yeah.
that particular agreement or that particular transaction,
Yeah.
and eventually adhering strictly to the terms of whatever arbitration clause that they have actually agreed
I
upon.
think I just wanted to add one bit, just a little thing that I don't think we quite covered. So there's also, parties can also think about what to do when the dispute has arisen and while the dispute is being resolved, because sometimes dispute resolution can take some time.
Yeah.
So you also want to think about the likely impact on your contract and how to hedge against that.
Yeah.
So if you were a construction contract, for instance, you can have a clause that says that the fact that there is an ongoing dispute or claim that we're trying to resolve will not stop the continued performance of. We're going to allocate damages when we get to that stage, but meanwhile the work will
still continue. That's definitely the most sensible thing to do in such an instance. So yeah, thank you so much, Joy. It was a delight having this conversation with you.
I love being here with you.
All right, thank you.